Welcome, welcome. Come on in. Yes, another impromptu Law of Self-Defense live show. We're going to do a live Q&A today. See as people filter in. Hopefully, here we go. All right. Perfect. Looks like we're streaming live just like we're supposed to be. Take a look here at Take a look here at Rumble. Yep, Rumble is working. Take a look at the Law of Self-Defense member dashboard where our members can join us. Oh, that's a little bit slow. Anyway, today is Tuesday, April 26th. I've been gone a few days. Here's the member dashboard. Here's the live show for our members. And that is working as well. All right, awesome. So I've been gone a few days. I've been at the CCW Safe Affiliate Summit. This is a gathering of CCW Safe with some of its more, I guess we'd call them prominent partners, just discussing ways to move forward and make the world a better place for everybody, particularly in the context of self-defense, quote unquote, insurance, what of course CCW Safe prefers to refer to as legal service memberships, because they really, none of these companies actually offer insurance. They'd have to be insurance companies then. So insurance is the wrong name for what they do, but it's what everybody calls them. So I'll just put it in scare quotes. It was a productive weekend. I'm always happy to be invited to these events by CCW Safe. Lots of great people there. Old friends I get an opportunity to see again. Did a little shooting at the CCW Safe home range. Great dinner. Great group of people over there. So I had a good time, but it did pull me out of the office for a few days, which is why I've been a little scant in terms of my presence here on our channel. Good morning, everybody. Come on in. Why am I so handsome? Yes, of course. It's an excellent question. Just the way it is, folks. So what I plan to do today is go through a bunch of questions that have been piling up. For those of you who are Law of Self-Defense members, you'll know that our Platinum members have a Platinum-specific Q&A form that they can use to submit questions to me personally, and I promise to answer them personally. If they ask that the responses be confidential, we respond to them directly, confidentially, of course. But most of the time, they don't ask the question to be confidential. Of course, we don't identify the person asking the question, but we'll share the answer with all of you. Yeah, I can't say it was restful this last trip over the last few days with CCW Safe. It was a lot of fun, but yeah, I took a nap yesterday afternoon when I got home for sure. I needed it. But back on the normal 5 a.m. to 9 p.m. schedule for this week for sure. All right, so let's see. People are filtering in. That is great. I should, of course, mention the sponsor of today's content, and I'll probably do this a couple of times because the sponsor of today's content is me, is Law of Self-Defense. Let me pull that up because, as some of you may know, we're in the process of doing a series of what we call our Law of Self-Defense hard to convict webinars. Where's my little picture for that? Come on, folks. Good heavens. Oh, it is here. All right, let me share this screen with all of you. Okay, adjustments, all the adjustments. So let me share this tab with all of you here. Chrome tab, here we go. All right, so today's show, today's live Q&A is sponsored by the Law of Self-Defense Hard to Convict webinars. These are a series of 100% free webinars we're doing to show you how to transform yourself from being easy to convict to being hard to convict. And you can, in fact, make yourself extremely hard to convict if you know what to do. And that's what we show you as part of this webinar. We also engage in a bunch of myth busting, commonly believed self-defense law myths that, if believed and if followed, are really just a high-speed path to prison. So we want to explain to you why you should not do those things. And you can learn all that at our lawselfdefense.com/hard to convict webinars. They're free, but they're limited to 100 seats each. That's so I can handle the Q&A, the live Q&A we do at the end. And so I would encourage you, if you're interested, to grab one of the seats while they're still available. So we have one of these webinars tomorrow, Wednesday, April 27th at 2 p.m. Eastern time. And you can sign up for your seat. If there's any left for tomorrow, you'll have to check when you get to this page at lawselfdefense.com/hard to convict. If tomorrow's date is not listed, it's because it's sold out, but there'll be other future dates that you can pick from. I think the next one's like 3 weeks away or so, folks. So if you're interested in learning how to become hard to convict, I would encourage you to sign up sooner rather than later. And you can do that at lawselfdefense.com/hard to convict. Yeah, I see in the comments a few people are more interested in the Johnny Depp Amber Heard trial coverage. That's totally fine. I don't take it personally. If that's what you want to watch, you'll be much better off at Nick's channel or one of the other law tubers who are covering that in depth. I'll probably jump over to Nick's channel myself a little bit later today just for the camaraderie. But here at Law Self-Defense, we don't really do much Depp v. Heard type stuff. We're pretty much exclusively focused on use of force law. So if what's happening with Johnny Depp and Amber Heard is of greater interest to you, good luck. I'll see you later, maybe. For the rest of you, we are here to cover use of force law and live question sent-in. By the way, so I mentioned earlier, the questions I'll be covering today are ones that have kind of piled up from our Platinum members using that Platinum member live Q&A form. But if you want to ask questions live during today's show, you can do that in super chat form, and I'll be glad to address all of that. All right. So what else do we have to cover? I'll stop that. And let's see. I don't have a form of little entry music today. Sorry. We'll just have to do without. All right. So let's get to the Q&A form questions. It's a good one from Blake. Blake asks, at what point does it become trespassing if you are carrying on the property of a business that has a sign saying weapons aren't allowed? Is it immediately when you set foot on the property, or at some point later in the event that they notice you're carrying and ask you to leave? That is a great question. And you may be surprised to learn that technically the trespass occurs instantly. The moment you're on the property without license, without permission, and you're on the property without permission, the moment you're breaking their rules that are conditions for being on the property with permission. So presuming you're aware they have the sign posted and they don't want you on the property with a weapon, and you enter the property with a weapon, you're technically committing a trespass right there. Now, as a practical matter, it's not like, Delta Force is going to parachute out of the sky and arrest you for that technical trespass. First of all, the store doesn't know you're trespassing, presumably, if you're carrying concealed and doing so in a responsible manner. So they certainly can't levy a charge of trespassing for conduct they're not aware of. But if you were to have a, fatal stroke, drop dead right there, and the EMS comes and discovers you with a gun, well, it turns out you were actually trespassing on the property, regardless of whether or not you were told to leave. Now, what happens as a practical matter is it doesn't become an issue until you're told to leave. And you're not told to leave until the property owners become aware you have the gun. And they generally don't become aware you have a gun unless you're acting like an a-hole. Those are the people who tend to get jammed up on things. Or you're not competent to actually carry concealed. So you're carrying in a way that other people can tell you're carrying a gun, which is not an effective way to carry concealed. So don't do that. Now, what tends to happen is once they become aware you have a gun and they want to make something of it, then they'll ask you to leave. and or call the police, or ask you to leave. And if you refuse, then call the police. And then you're really acting like an a-hole. And you should not be surprised when you run into legal difficulties, including the cops cuffing you up when they show up. So just don't do any of that. The smart play is, as an officer of the court, I have to tell you to obey the rules. If you're not comfortable obeying the rules, if you're not comfortable entering that property without your gun, you might consider not entering the property. It's one of the reasons, by the way, the property owner doesn't have any legal liability if you enter the property leaving your gun behind, as the sign requests, orders, really. And then there's a use of force event and you can't defend yourself because they didn't let you have your gun. Well, you volunteered to enter that property without your gun. Clearly, even you didn't think there was a real risk of facing a deadly force attack, or you would never have agreed to enter the property without your gun. You would have chosen not to enter the property. So the mere fact that you entered the property without your gun suggests that you yourself believed there wasn't real risk there to worry about. But as a practical matter, what happens is it tends not to be an issue until they know you have the gun. They don't tend to know you have the gun unless you did something that would enable them to know. Once they know and they ask you to leave, you'd be smart to just leave and be happy you got away with a kind request. But they could just call the cops. They could permanently trespass you from the property. They could ask that you be charged with civil or even criminal trespass. And you could be facing all kinds of problems. And of course, in some states, the posting actually has criminal legal effect. So it's actually a crime, a gun crime in and of itself to have disobeyed the sign. And then you can find yourself in a real jam. So the real answer to the question is be smart. And don't be the guy who gets made carrying concealed, because then you weren't really carrying concealed. All right, let's see the next question. Great question, Blake. Gary, a common questioner. But it's more administrative. He had attended one of our law self-defense advanced courses, wanted to know when he could review the video. Presumably, we followed up with you, Gary. We sent everybody emails after the fact of that class, so hopefully that got taken care of. All right, next question. Let's see. So it's not really a question. It's a road rage incident out of Florida. I'll have to take a look at that case and see if it's sufficiently interesting. It's described here in the quote unquote question as a road rage incident where I guess two cars collided. One of the drivers became enraged, deliberately crashed his car into the other, then fired a shot at the other driver, and the other driver had his own gun, returned fire, and killed the initial aggressor. I'll take a look at that case and see if it's worth covering in more detail. Let's see. Okay, this is from Mike. Mike asks, on another channel, ethical preparedness. Okay, I've never heard of it. Maybe I'll check it out. This former officer made an interesting comment that we should shout, drop the weapon multiple times if we're involved in a self-defense incident prior to and during firing. He links me to the video. I'll check that out, Mike, and see if it's worth sharing. He also states that several states require this verbal command. No. That's just made up nonsense. It's amazing how much myth and nonsense there is in the self-defense community. And unfortunately, much of it is propagated by people like former police officers. I mean, it's just awful. Now, he may be just misinformed. That would be very common. I mean, he himself was taught this and he believes it to be true because he respected his instructors. Or he could be propagating department rules that are not laws that apply to the rest of us. They're not crimes for which you can be prosecuted. Even he couldn't be prosecuted for it. At most, it would be a job employment issue. But there's no state in the country that requires as a condition of lawful self-defense that you shout commands first. I will say, if you have the opportunity to shout commands and you have a reason to believe that might solve the problem without you having to shoot someone, and you can do all that consistent with safety, it seems to me that would be the smart play. but there's no requirement. There's no legal duty that you shout commands before you can act in otherwise lawful self-defense. Mike continues, I can see how this might be a requirement for law enforcement, but surely this isn't mandated anywhere pertaining to private citizens, is it? No, it's not, Mike. By the way, it's not even required for officers. If you look at the officer departmental regulations for this kind of thing, the mandate is always phrased as if you can give verbal commands consistent with the safety of yourself and other innocent people. You're not supposed to first try verbal commands if the aggressor is in the process of murdering people. You're allowed to defend those people. You're allowed to defend yourself against an imminent deadly force attack without first having to try a verbal command. I mean, what kind of ethical structure would that be? That while someone's being killed, before I can do anything to stop that lethal attack, I have to shout words at them, even while an innocent person is dying at their hands? It's ridiculous. So Mike continues. This former officer also talks about the number of shots, saying that we typically train for 2 to center mass, then stop and reassess. That most people are going to typically rapid fire a lot more than that in rapid succession. That would be pretty common. Essentially, a mag dump or close to it is my read. My question is, if multiple rounds up to a mag dump are fired in the heat of the moment, does the law actually convict you of that? I would imagine the DA will infer murderous intent, but isn't this a subject call? All right, so let's talk about the number of shots fired. First of all, the DA will tell the jury to infer murderous intent, by which I would rephrase that as an intent to cause deadly force harm. The moment you point a gun at someone, you're doing that, especially when you fire the gun at them. The law allows for an inference that you're using deadly force against that person. You intend the foreseeable outcome of that use of deadly force, which is death or serious bodily injury. It's not necessarily murderous intent. If it's done in lawful self-defense, then it's not murder. It's, lawful self-defense. It's legally justified. But you are intending death or serious bodily injury. I mean, that's inherent in the use of deadly force in self-defense. Not necessarily intending to kill, but certainly intending to cause sufficient injury to stop whatever the threat upon you is. That's one of the ways Kim Potter jammed herself up in her trial. The prosecution kept saying, so you intended to kill him. You intended to kill him. And she said, yes, I intended to kill him. Well, what she intended to do was use deadly force upon him. But if the deadly force would stop the threat and not kill him, that would be better for everybody, including for Kim Potter. Sorry, I'm not talking about Kim Potter. I'm talking about Amber Geiger. This is the accidental, went into the wrong apartment shooting case. Amber Geiger, not Kim Potter. Kim Potter's, of course, the taser female officer. So if Amber Geiger had said on the witness stand, well, no, I never intended for him to die. I never wanted that. I just wanted to stop what I perceived as an imminent deadly force intruder into my apartment, mistakenly, but genuinely believed that to be the case, would have had a very different impact, I think, on the jury and frankly on the public. But she allowed herself to just get railroaded by that prosecutor and saying she had an intent to kill. So the number of shots. So technically, what the law requires, if you're acting in otherwise lawful self-defense, is you can continue using deadly defensive force as long as you need to neutralize that unlawful, imminent, deadly force threat against you or against some other innocent person that you may be defending. And if that takes one round, well, then you're only allowed the one round. I mean, that's the other thing. This privilege to use force, it appears and then it disappears. So it appears while the threat is imminent, actual, or immediately about to occur. And then the privilege disappears when the threat's resolved, when it's no longer there for whatever reason, because the aggressor ran away or they've been physically or psychologically neutralized, so they're no longer presenting as a threat. Then the privilege to use deadly defensive force ends. As long as the threat exists, however, the law says if you're privileged to use deadly force at all, you're privileged to use it as long as that threat remains. That could be one shot and then your privilege ends, or 2 shots or 3 shots, or in theory, 10 shots or 15 shots. Some of you might remember the Hollywood bank robbery where the bad guys armored themselves up in heavy clothing and body armor and all kinds of stuff. And The cops responded and fired a ton of shots at these guys, and it took forever to neutralize them. The cops weren't limited to firing 2 rounds or 4 or a mag or 2 mags or 10 mags or a 30-round mags from an AR. They're privileged to use as much force as necessary to neutralize that deadly force threat. The same for you. Now, here's the issue, of course, and that is that we have a jury, the public has kind of a general expectation of how many rounds it really takes to neutralize somebody. And the more rounds you use, the more a prosecutor can argue, come on, isn't this really too many? Isn't this excessive? Did it really take 10 or 15 rounds, a mag dump, to stop this guy? Now, maybe it did. And if it did, every shot is justified. But if it didn't, the more it can be characterized as a use of force that continued past the point where there was still an imminent threat, well, then all those additional rounds are excessive force and not privileged and not justified as lawful self-defense. So if say you're a USPSA Grand Master and your trigger splits are 0.15 or 0.18, and you can empty that 15-round mag in your pistol pretty darn quick, is that the smart way to go? I mean, do you really need to put 15 rounds into the person to neutralize them? I mean, maybe they're wearing body armor. Maybe they're unbelievably obese and their body fat is catching the bullets. That happens in real life. So that the rounds are not actually hitting vital structures that would neutralize the person. Maybe you're missing a lot. I mean, that would be not good. So you don't want to do that. And the actual area volume that you actually have available to shoot at that would quickly neutralize against their will a deadly force aggressor is not very big, folks. It's basically a orange or grapefruit size sphere, upper center mass, where the heart is and the big blood vessels, the aorta and the pulmonary arteries. Even that's not necessarily instant, but it's usually pretty decisive. But there's lots of places you can shoot the human body and not get a decisive stop. So if you're doing that, if you're just spraying rounds into a person, it may take more rounds. And the more rounds may look suspicious, may look unnecessary, may look like more driven by personal anger and malice than by necessity. So the smart play is to, by the way, the same can happen with small caliber guns. So you have a 22 long pistol or rifle or whatever that you're using to defend yourself. 22 long rifle is a very lethal round. Lots of people get killed by it, including another rounds we think of as relatively minor, 32, 380. But these rounds kill people all the time, folks. They just don't stop them. The person dies eventually, but they're not stopped in the moment, which is what we should be concerned about in self-defense. But if you have a minor caliber defensive round, you may end up having to put a lot of rounds into that person. And the jury's not really going to distinguish much between, if you fired 15 rounds into somebody, well, it was only 15 rounds at 22 after all. It's not like it was 15 rounds at 45 or 40 or 9. The jury's just going to hear the number 15. So obviously, as I always emphasize, you have to survive the physical fight or everything else becomes moot. And if it takes you 15 rounds to survive the physical fight, if the alternative is that you die, well, then I guess you have to fire the 15 rounds. But that's not the outcome you'd want. The preferred outcome would be that you're sufficiently capable with your defensive tool in terms of shot placement, that you can get solid hits on that aggressor. And frankly, there's a lot of instructors today that guys I respect, and I mean actual tactical self-defense instructors, who would suggest that a pretty good pace for a self-defense shooting is splits of about 0.3. Now, that's 3 shots a second. That's pretty quick. It's not as quick as a competent competitive shooter. I'm not world-class anymore, and I wouldn't have any trouble doing 0.2 splits. But 0.3 is a kind of pace where you can be confident the front sights come back down. You've got a good sight alignment on the target. You are having an opportunity to kind of see if the person's still standing, still presenting as a threat, still has the weapon in their hand, whatever the case might be, and do a real-time evaluation so that in fact you don't find yourself using rounds that you don't need to use, using rounds after the threat's no longer been neutralized. So, I mean, the bottom line is technically you can continue firing shots as long as you need to. But whether or not you actually needed to is, of course, going to be a subjective call made by other people, made by the police, made by the prosecutor, made by the judge, made by the jury. And their subjective perception may be different than yours. And it's not yours. It's not your subjective perception that controls the legal outcome in your case. It's the subjective perception of these other people. So it's best if you can conduct yourself in self-defense in such a way that what you actually do appears consistent with their subjective expectations for what genuine self-defense looks like. If you have to go beyond those boundaries, or the alternative is death, you die, well, then I guess you have to. But that's not what you want to do. That's not the optimal outcome, right? You want to be able to effectively defend yourself in such a way that you're also well positioned to win the legal fight that follows. So to wrap up, there's no legal requirement that you give verbal commands when you're acting in otherwise lawful self-defense. But if you can, and it might help, and it might prevent you from having to actually shoot someone, and you can do that, give those verbal commands consistent with safety, and especially if you're not sure about what's going on, which is very common in good guy cases of self-defense. It's unclear what the threat is. You're in that zone of ambiguity, and verbal commands can often help strip away that ambiguity and compel that other person to either stop doing what's scaring you or to oblige them to act consistent with the conduct of an aggressor. So if circumstances allow, verbal commands are probably a good idea if it can be done consistent with safety. But if you're facing an actual imminent threat of death, there's no place no place in the U.S. at least. I don't know about outside the U.S. There's no jurisdiction in the U.S. that requires as a legal duty that you first give verbal commands before you're otherwise privileged to defend yourself against a deadly force attack. And in terms of the number of rounds, look, the fewer rounds you can use to effectively defend yourself, the easier it is to articulate the reasonableness of that round count. The more rounds you use, especially if it gets extravagant, the more difficult. The easier you make yourself to convict, because you give the prosecution stuff to work with. And you don't want to give the prosecution stuff to work with if you don't have to. If you have to, you have to, and then you deal with it after the fact. By the way, I will mention that where people tend to get into trouble in the real world is not that they literally do a mag dump on somebody, put 15 rounds into them. It's where they fire 2, 3, 4, 5 rounds, and then there's a pause in the action. And during that pause in the action, the aggressor is in fact neutralized, and the defender had an opportunity. A reasonable defender would have seen that the aggressor is now neutralized. And after that pause, they shoot again. That's where people tend to get into trouble on this. And the first 3, 4, 5 shots might be perfectly lawful, but after that pause, you fire again. There's no longer a threat. You get prosecuted for murder on that last shot for sure. That's the most common scenario. Okay, let's see where we're at now. Let me take a quick look at the super chats. I see there's one come in from William Andrews. Thank you, William, for your. In fact, let me do this the proper way, the Nick Rakita way. Here we go. All right, Andrews asked, do you have body armor? Is that a bad guy look in self-defense? Well, I would suggest it depends on the circumstance. So yes, I own body armor. I own soft body armor. I own plate carriers. I don't walk around in public like that. That would be an odd look for sure. But when I was actively teaching people on the range how to shoot, I mean, I have been for decades an NRA certified instructor in pistol, rifle, personal protection. I've taught a lot of students on the range how to shoot. A lot of them are, open enrollment classes where, I mean, it's the ultimate novices coming in, people who barely have ever handled the gun before. So you do worry about getting shot by those people. So yeah, when I was teaching on the line, I would wear soft body armor just in case, right? Or for home defense, or if you're worried about kind of a riot, looting, arson type of scenario coming to your neighborhood, if I'm going to be bunkered down in my home, yeah, then me and my wife, Emily, have plate carriers, and we're, prepared for the worst case scenario. I don't intend to go out in public wearing a plate carrier and with a AR slung around my neck. That's not something I would tend to find prudent in a non-post-apocalyptic society. But in my own home, sure, I want all the possible protection I can get. But again, if you go out in public wearing body armor like on a routine basis, it's going to be an odd look. Now, does that lose you self-defense? It doesn't lose you self-defense any more than, if you're drunk and you defend yourself, you don't lose self-defense. One of the elements of self-defense is not, and he was not intoxicated, or he was not wearing body armor. You have all the same privilege of self-defense you had if you were sober or if you weren't wearing body armor. But again, I always advise that. So in the context of being drunk, you have all the usual privilege of self-defense. But if you make bad decisions because you're drunk, if you violate one of those required elements of self-defense, you don't get a break on the analysis because you were drunk. You own that bad decision. That's on you. In terms of body armor, you're just giving the prosecution something. You don't look boring anymore, and you want to look as boring as possible to a prosecutor. You want to give them as few oddities to talk about to the jury as you possibly can. What might a prosecutor argue if you're going out wearing body armor on a routine basis or for some special event? He's going to argue that you were looking for a fight. I mean, cops wear body armor because they're tasked with being the initial aggressors when they're making an arrest, for example. Cops are tasked with going to the fight. You're not, if you're not a cop. Your job is to get away from the fight, not go to the fight. If you go to the fight rather than the fight coming to you, it doesn't really look like self-defense to anybody. If you're going someplace, listen, if you carry concealed, I carry concealed. I have every day of my adult life. If you're carrying concealed and you're going someplace and you're like, man, I'm sure glad I have my gun here. Well, that's a pretty good clue. You might not want to be there. Or if you're going someplace and you're saying, well, man, if I'm going to go there, I really want to bring my gun. Why are you going there? I mean, what's compelling you to go someplace where you really exceptionally think you would need a gun there, as opposed to when you just happen to be carrying your gun in the normal course of events, if you routinely carry concealed every day, as so many of us do. Why are you going someplace where you feel now, I have to say, on body armor routinely, then I would wear it routinely, because then you can at least say, hey, I wasn't expecting anything particularly bad to happen. I just wear this every day because I'm odd that way. But if you take specific steps to prepare yourself for violence in some unusual way outside your norm, the prosecution is going to say, well, you knew what you were getting into. You were going to the fight. So I would be disinclined to do that. Let's see. Yeah, don't forget our hard to convict webinar. We have one coming up. What happened to my hard to convict webinar? Let's see. There it is. We have one coming up tomorrow, folks. That's April 27th at 2 p.m. Eastern time. They're 100% free. We keep them under 2 hours. We bust a bunch of common myths of self-defense law so you don't railroad yourself into a prison cell if you're compelled to defend yourself, your family, your property. And we show you how to transform yourself from your current state. It's almost certainly your current state. You are easy to convict if you use force against another person in what you believe is self-defense. Transform yourself from being easy to convict to being hard to convict. It's not that hard to do, but you need to know the process. So we share that process with you in these hard to convict webinars. We don't charge a penny for these, but you do have to sign up because they're each limited to 100 seats. So I can adequately handle the Q&A portion of those. So if you'd like to become hard to convict, then I would encourage you to participate in one of these webinars. Now, if you go to this page to sign up, lawofselfdefense.com/hard to convict, and tomorrow's date is no longer listed, it's because it's full. But there should be later dates you can also sign up for. When I checked this morning, we still had a few seats left for tomorrow. So if you're at all interested, I would encourage you to take advantage of that. Here's an interesting question. Berengi asks, are self-defense laws different inside prison? Well, yes and no. So the same 5 principles of self-defense that I often talk about are the same. You have the same privilege of self-defense in prison as you do out. There are some special provisions for self-defense in the context of highly defensible property, like in the context of your home. Like you might be relieved of a legal duty to retreat, for example, if you're defending yourself in your home under the castle doctrine, or you might get the benefit of a legal presumption that your fear of imminent death was a reasonable fear if you're dealing with a forcible, unlawful intruder into your dwelling. There are states that pass those special provisions in the context of highly defensible property that exclude prison cells. So, if you're in prison, you're living in your prison cell, arguably that's your dwelling, right? That would be your castle. But often, because these special provisions for defense in the context of highly defensible property, they're passed by the legislature, there's debate, there's compromise, and often they'll ultimately put in an explicit exclusion for prison cells. You wouldn't get the benefit of those special provisions. But absent that consideration, in prison, you generally have the same rules same 5 elements for self-defense as any place else. All right, let's get back to our backed up questions here. Last one was from Mike. Let's see what is next. Let's see. So it's a good question. Let's see. Is there a name? Dave. Dave asks, in a hypothetical situation in which a person were standing at the top of a stairway of significant height, say it's a 10-foot stairway. The point is, it would be a stairway. If you fell down it, you would be subject to a reasonably foreseeable prospect of serious injury. You're rushed by someone, presumably larger than you, and they try to shove you down the stairway, is the fear. Would deadly force be justified if the defender is concerned that if they get knocked down the stairs, that could be a deadly force attack, even if the attacker were not obviously armed with a deadly weapon? And then they mentioned the Theodore Edgecombe case. This seems to be could have been a possibility in the Edgecombe case. Edgecombe was standing near the top of a flight of stairs with his bicycle when he was approached by the victim, fists raised, and he shot the victim in the head, killing the victim instantly. Edgecombe was recently convicted of murder in that case, or at least manslaughter. I forget what the ultimate conviction was for. But one possible scenario was Edgecombe might have argued that, hey, I was at the top of the stairs. I was afraid of being pushed down the stairs. In that case, it wasn't really credible because at the moment he shot the other party, the victim was really standing in position. He was not trying to shove Theodore Edgecombe anywhere. He was not still closing on Theodore Edgecombe. He was standing several feet away with his fist raised, basically, and hey, do you want some? Come and get it. No longer advancing on Theodore Edgecombe. So I don't think the argument would have worked there. But from a more hypothetical perspective, the question is always the same, folks. Was there evidence, observations from which the defender could reasonably infer a reasonably foreseeable imminent threat of death or serious bodily injury? And maybe getting shoved down a flight of stairs would qualify as that. Certainly, we can all imagine stairs where that could be the case. We can all imagine someone rushing at us with an apparent intent to violently throw us down a flight of stairs where you could break your neck, break a leg. All of that would be serious bodily injury. The caution is that it's not enough just to be able to articulate that. You have to be able to articulate that perceived danger in an evidence-based way. It can't just be speculative. Well, he wasn't really advancing at the moment, but for all I know, he could have advanced and shoved me down the stairs. That's not compelling as compared to someone who's actually rushing at you, arms outstretched, in an apparent attempt. If their conduct continues in the way you're observing it, you'll be shoved down the stairs. That's compelling. The theoretical or speculative or imaginary prospect that if they changed their conduct in some way, they might throw you down the stairs, that's not an imminent threat to my mind, because anybody is a theoretical, speculative, imaginary threat in some way. So it has to be more than that. Again, the threat you're defending yourself against has to be imminent, either actually occurring or immediately about to occur. And the perception of the imminent threat has to be reasonable, meaning you're applying your powers of reason to actual evidence before you. It can't merely be speculative or imaginative. So that would be the answer to that particular question. Let's see any super chats on that before I move on. All right, so the next backed up question, we got about 10 of these to go. Well, the next one, unfortunately, is a gun question, a gun law question. And I don't do gun law, folks. So I don't do concealed carry licenses. I don't do what kind of permit do you need for what kind of gun and what kind of state. But the question is, I have two houses, one in Missouri, one in Colorado. Where should I get my CCW, with Missouri or Colorado or both? Again, so I said I don't do gun law. I happen to live in Colorado, and I don't believe Colorado makes non-resident permits available. If you claim residency in both states, might either one of them argue that you were lying, that you can really only be a resident in one? I don't know, folks. I would try to cover myself in both states if I possibly could, but I don't do gun law. So you'd want to talk to a gun law lawyer about that. Personally, I like having as many permits as the state authorities will issue me, because I think it puts me in a more defensible position. It can get expensive, but in the in the greater scheme of things, an extra 100 or 150 bucks for a permit that kind of gives you an imprimatur of lawfulness, because you got background checked, you took the course, you got all that stuff, your photo taken, a little card issued to you by the government. It doesn't hurt to have that. Okay, the next question. Well, it's from Harold, and Harold is asking about our law of self-defense hard to convict webinars. Oh, I still have the little image up there. So you can sign up for our 100% free hard to convict webinars. Learn how to transform yourself from being easy to convict to being hard to convict. They're free, but there are limited seats for each webinar. The next webinar is tomorrow, Wednesday, April 27th at 2 p.m. Eastern time. And then we have other dates. I think the next one after that was 3 weeks or so down the road. You can sign up for any of them that still have seats available at lawofselfdefense.com/hard to convict. And these are proving very popular, folks. Every single one of them is full when I start the webinar. So if you're interested in attending one of these, I would encourage you to do that. Sign up sooner rather than later at lawofselfdefense.com/hard to convict. Because let's face it, when are you going to need this knowledge of how to be hard to convict? You don't know. It's not up to you. You don't get to choose the time, place, and manner in which you're attacked. The bad guy does that. And once you're engaged by the bad guy and you're making decisions and engaged in actions and conduct, well, I'm stuck with the facts you give me as your lawyer. Any lawyer is stuck with the facts you give them. We don't have a time machine that lets us go back and change what you did. You have to have made the right decisions in the moment, and that's what makes you hard to convict. And you can be super hard to convict, by the way. I mean, a robust claim of self-defense is very rarely brought to trial or even charged, because the burden on the prosecution is so high. But unfortunately, many cases of self-defense, I'd suggest the majority, the defender himself makes himself easy to convict. He weakens his claim of self-defense by engaging in conduct that he thinks is lawful, but in fact is really not. He steps over the legal boundaries without knowing it, because he didn't know where the actual legal boundaries were. He was mistaught. He has misunderstandings about where the legal boundaries are. You don't want that guy to be you. You want to be the guy who's not easy to convict. You want to be the guy who's hard to convict. And since you don't get to choose when you're going to have to be hard to convict, I would suggest it's better to be hard to convict sooner rather than later. Are you going to be attacked this afternoon? Are you going to have to point a gun at someone tomorrow? You don't get to make that call, do you? So do it sooner rather than later. All right, back to the questions. Yeah, so those are the webinars. That was from, well, he didn't give his name. Okay, that's fine. Let's see, Jim. Well, that's an administrative question. So I'll follow up with Jim separately. Let me send a quick note to staff. Okay, and the next question from Gary. Again, Gary, very common questioner. He takes full advantage of this platinum privilege to submit questions. Okay, actually, another administrative question. I'll forward that on to support. And we're back. I keep looking. And by the way, folks, if you're watching this live and would like to submit your own question, just put it in super chat form, and I would be happy to address that as well. Let's see. Okay, so this is a good one. All right, this is from Chuck. He says a change to the Self-Defense Act in Oklahoma has passed the House, is waiting for Senate action. Essentially, it allows an individual whose motion to dismiss is denied the right to an interlocutory appeal to the district court if, after the appeal hearing, the court concludes that the defensive force used was not justified and was thereby unlawful. The state must prove by clear and convincing evidence that the defensive force was not justified. How does clear and convincing evidence compare to beyond a reasonable doubt? So, Chuck, I'm a little unclear on the procedure here because you're using certain terms of arts in ways that are ambiguous to me. So I'm going to try to generalize your question and still give you an answer. So you can imagine where you've used force in self-defense. You believe it was lawful self-defense. The prosecution looks at the case and says, no, we want to take this one to trial. Your defense attorney is trying to get them to dismiss or at least put you in a diversion program. But the prosecution says, nope, we want to take a shot at this before a jury. So off to trial you go. In states that have a self-defense immunity provision in law, you can then request a pre-trial hearing. You request a self-defense immunity hearing. And as the person making the request, as the person moving for the hearing, think of it as the plaintiff there or the complainant. You have an opportunity at that hearing to present your argument for self-defense to a judge. So there's no jury in a pretrial hearing. The judge acts as the finder of law, like judges normally do. And for purposes of the self-defense immunity hearing, the judge is also acting as the finder of fact, the role of the jury normally in a trial. But there's no jury in a pretrial hearing, so the judge is doing both. And basically what you're doing is you're arguing to the judge in this pretrial immunity hearing your narrative of self-defense and trying to convince the judge that what you did was self-defense. And if the judge agrees, then he can grant you immunity from prosecution and or from civil suit, depending on how that particular state has set up their self-defense immunity. For our purposes, let's focus on just criminal prosecution. So the pretrial immunity hearing judge, if he buys the narrative of self-defense, he can grant you immunity from prosecution, and then the prosecutor's done. There's nothing more they can do. They can't take you to trial. And the nice thing about these pretrial immunity hearings is you get to a final adjudication of self-defense in a fraction of the time and at a fraction of the cost and a fraction of the risk that a full-blown trial costs. So the pretrial immunity hearing may cost you a few $1,000s. It may take a few weeks. The hearing itself could just be a day or maybe a few days long. In contrast, the full-blown trial could be hundreds of thousands of dollars and could take months, sometimes years. So the pretrial immunity hearing is better for you in terms of time and money. It's also, of course, lower risk because if you lose the immunity hearing, you can still argue self-defense at trial. So it's not like you've lost the issue of self-defense. Whereas if you lose self-defense at trial, you're just guilty. So the risk is the legal risk is much lower in the immunity hearing as well. Now, importantly, when I say, well, you argue self-defense to that immunity hearing judge, and if you convince him of self-defense, you can be granted immunity by that judge. That's a more complicated question than it might sound like on the surface, because convince him to what degree, and whose job is it to convince the judge? Is it really your job to convince the judge of self-defense? Or once you've put forth your narrative of self-defense, is it the job of the state to dissuade the judge that it was self-defense, to disprove self-defense? And if someone has the burden to prove or disprove something, the next question is, well, by how much evidence? By a preponderance of the evidence, 51%, by evidence beyond any reasonable doubt, by something in between those two things, which is clear and convincing evidence. So in all these states that have these self-defense immunity hearing procedures, someone has to decide who bears the burden. Does the defendant have to prove self-defense, or does the state have to disprove self-defense? And once you've decided who has the burden, then how high is the burden? Preponderance, or one level up from that, clear and convincing evidence, or one level up from that, the highest level, beyond a reasonable doubt. Now, once you get to trial and you raise a claim of self-defense, there at trial, the state has to disprove your claim beyond a reasonable doubt. That's a very high burden on the state. That's what makes you hard to convict if you have anything like a reasonable claim of self-defense. At the pretrial hearing, however, it's more varied. So often the rule will be, and this varies by state, but often the rule is that at that pretrial immunity hearing, the defendant has to prove self-defense. He has the burden to prove self-defense by a preponderance of the evidence, which means a majority of the evidence, 51% of the evidence. If he can do that, he gets immunity. And if he can't do that, if the state can argue against self-defense by 51%, then immunity is denied. But there are other states, Florida is one, and it sounds like maybe Oklahoma is trying to do the same thing here, where the burden is not on the defense to prove self-defense. The burden's on the state to disprove it. And the height of that burden on the state is not merely a preponderance, but something called clear and convincing evidence. So what is clear and convincing evidence? Well, it's something between preponderance, 51%, and at the low end, and beyond a reasonable doubt at the high end. Now, we don't have a numerical figure for what it means to disprove something beyond a reasonable doubt, but it's a very high burden. So let's say it's 90% of the evidence or 95% of the evidence. We have preponderance at the low end, 51%. We have beyond a reasonable doubt at the high end, 95%. Where is clear and convincing evidence? It's somewhere in between there. Maybe it's 60%, 70%, 80%. The truth is nobody really knows. It's a very subjective description. It's more than a preponderance, that's for sure. It's less than beyond a reasonable doubt, that's for sure. But where exactly between those two extremes you find clear and convincing evidence is basically going to be a judgment call made by the judge in this pretrial immunity hearing. So it's nice in that this kind of standard is nice in that it's favorable to the defender. So he not only doesn't have the burden of self-defense, not only is the burden shifted to the state, but the state has to do quite a bit more than disprove self-defense by 51%. They have to do it by whatever clear and convincing evidence means to that judge. More than 51% for sure, but not quite beyond a reasonable doubt. When they get to trial, then the burden's on the state to disprove self-defense beyond a reasonable doubt. So that is hopefully a useful answer to that question. Let's see what else we have. We have another super chat from Chris. Thank you very much for your super chat description. Can you talk a little about defensive display? Would open carry be a form of defensive display? What are the thresholds for display? It's a great question, Chris. One of the most common we get. And the truth is that defensive display, whether or not that would qualify as a crime, is completely subjective. It could qualify as brandishing, which is typically a misdemeanor offense. It could qualify as aggravated assault with a firearm, which is a felony, good for 10 to 20 years in most jurisdictions. Or it could simply be a lawful defensive display and no crime at all. The answer is nobody knows, because it's all going to be evaluated on a case by case basis by different individuals and different circumstantial facts and within a different social context. So, what would be deemed to be a lawful defensive display in rural Oklahoma is going to be very different than what would be perceived as a lawful defensive display in Cambridge, Massachusetts. In Cambridge, Massachusetts, if you're simply walking around open carrying a pistol on your hip, that is going to shock the conscience of that community. It will attract law enforcement attention. And when I lived in Massachusetts, there actually was no law against open carry of a gun. But I can assure you, you will find yourself in legal jeopardy if you walk around Massachusetts open carrying a gun, at least any place that's outside of the Berkshire Mountains for sure, and perhaps even there. Because people are not accustomed to seeing it. People will be alarmed. You may as well be walking around with a live rattlesnake wrapped around your waist. They're going to be shocked. They're going to call the police. The police are going to come, and they'll find something to charge you with. And that might be brandishing, because you're putting other people in fear. Now, is their fear reasonable? I mean, you didn't take the gun out of the holster, but what would be a reasonable fear for someone in Cambridge, Massachusetts might be different than a reasonable fear if you're standing beside some guy in a cowboy hat, open carrying a revolver at the gas station in Oklahoma. So it's completely subjective. Now, the kinds of things, the factors that might be considered in coming to a decision on whether or not a display was lawful or not is, well, first of all, was the gun visible at all? Because if it's not visible, then no one can be frightened of what they can't see. So it's one of the reasons I'm not a fan of open carry. I mean, I think everyone has the fundamental constitutional right to open carry if they want to, or at least they should have that right recognized. I think any law against law-abiding American citizens, mentally sound American citizens, open carrying a gun is facially unconstitutional. So I think everybody has that right. I think it's imprudent because you begin to open up the door for problems you don't need to have. The moment someone's aware you have a gun, they have an opportunity to be afraid of that gun, to be shocked by that gun. Why give them that opportunity? What are you really getting from open carrying? I mean, that's obviously a personal decision you have to make for yourself. But if I was advising a friend or a client, I would advise against open carrying because it opens up the door to problems. So you're open carrying, but the gun never comes out of the holster. Is that brandishing? Probably not. I mean, normally you have to have put someone in fear of harm by brandishing, and a gun in a holster would not normally be expected to do that unless the community is Cambridge, Massachusetts, in which case they will be shocked. Or many parts of Metro New York, for example. But people will be shocked to see someone who's not obviously a cop openly carrying a gun. It's not normal there. It will shock the conscience. But in most of the country, if people see just an open carried gun, would that be brandishing? Probably not. Once the gun comes out of the holster, so you're actually scared of something. Say you're showing your buddy your gun. Hey, I got this new gun. Take a look. So you're not actually intending to direct the weapon at anybody. But if someone sees you handling a gun, I can tell you, if I'm in a Starbucks someplace and I see you take a gun out of a holster, you have 100% of my attention. Am I going to shoot you? Maybe not, but you have 100% of my attention because that's not normal conduct. By the way, the same if you walk into that Starbucks with an AR. Might that be lawful? Sure. You have 100% of my attention until I figure out why you're engaged in this unusual conduct. And by the way, you're scaring the hell out of everybody who also gets a vote on gun laws, who's not comfortable with that kind of conduct. So you might want to think about whether that's really advantageous to your long-term political future as a gun owner and your Second Amendment rights. But then imagine you perceive a possible threat. You bring your gun out to a low ready. You don't put the muzzle on the apparent threat, but you make them aware you have a gun for the purpose of defending yourself. A lot of jurisdictions, they have defensive display statutes, which basically say, hey, if you display the gun, but you're doing it for purposes of self-defense, that's not a crime. That's lawful. The trouble is someone has to decide after the fact whether you were doing it in lawful self-defense, which involves an analysis of those 5 elements of self-defense. And One prosecutor could decide it looks like lawful self-defense and therefore a lawful defensive display that fits within the scope of that defensive display statute and therefore is not a crime. And the prosecutor in the office next to him could decide, well, it didn't look like lawful self-defense to him. There was no deadly force threat, so going to the gun would not be justified. Therefore, because it doesn't fall within the scope of self-defense, it doesn't fall within the scope of the defensive display statute. So it wasn't a lawful defensive display. It looks to him more like at least brandishing and maybe aggravated assault with a firearm. And then there's other prosecutors' offices that'll say, hey, listen, if you don't put the muzzle on the person, we'll call it brandishing, even if it looks sketchy. I mean, maybe it's defensive display, but if we think it looks sketchy, we'll call it misdemeanor brandishing, and we'll prosecute you for that. But if you put the muzzle on the person, then you're looking at an aggravated assault with a weapons charge, assuming, of course, again, you can't justify it as self-defense. It falls outside the scope of lawful self-defense. And then you're looking at 10 or 20 years in prison and a felony conviction. And where along that spectrum, lawful defensive display, misdemeanor brandishing, felony aggravated assault with a firearm, where along that spectrum you fall is almost entirely the subjective judgment call of other people. So you can't actually know. You don't know ahead of time where that line is going to be drawn. It's drawn retroactively after the fact. So my usual advice is to be extremely cautious about making another person aware that you have a gun and you're prepared to use it to defend yourself. There can come a time in an escalating threat where that needs to be done, consistent with safety of yourself and other people you have a duty to protect. But if you can delay that time until the evidence consistent with the need to deploy deadly defensive force is as robust as possible, well, then you're in the most defensible position for having made that display. Personally, I'm very disinclined to make my gun obvious unless the conditions for the actual use of that gun have been met. And that's a pretty high threshold. Now, I will caution, often you display the gun and the other person realizes they brought a fist to a gunfight and they stop being an imminent threat. So I'm not suggesting that just because the gun comes out, you automatically discharge the gun. You automatically shoot someone. If the gun comes out and circumstances change and there's no longer an imminent threat, then you ought not be using that deadly defensive force. It's no longer required. You no longer have that legal privilege. But in terms of making the decision as is the gun coming out, I'm strongly disinclined to do that unless the circumstances are such that if they don't change, I would be privileged to fire that gun. Now, hopefully they will change. Hopefully I won't have to fire the gun. But the gun's not coming out unless I would be privileged to fire the gun if the threat continued on the path that it's currently taking. All right, so hopefully that answered that question. Let me get back to that super chat question. Let me get back to these. Let's see. He asks about the Michael Barrisone case. This was the horse trainer case where the woman and her boyfriend basically drove Michael Barrisone, the horse trainer, crazy, broke him psychologically and mentally, deliberately so, intentionally so, until things escalated to the point where he shot her twice in the chest and shot at her boyfriend. He was charged with attempted murder, 2 counts for both of those, and a gun offense and various other things. He was ultimately acquitted entirely for the use of force threat against the boyfriend, the firing the shot at the boyfriend. He was acquitted entirely on the gun charge in New Jersey, no less. And he was acquitted on the grounds of insanity for having shot the woman twice in the chest. And the question here is, can the excuse of duress be successfully applied? Now, duress is a circumstance. Normally, the duress would have to be more compelling than you'd see here. So duress, for example, would be where you go into a bank and you hand the teller a note, says, give me all the money in your drawer. So you're committing a bank robbery, right? And they do that. And they give you all the money in a bag, and you take the bag and you walk out of the bank. But the only reason you did that is your children are being held hostage and threatened with death if you don't rob the bank. Or in the movies, a bomb has been strapped to you and will be detonated if you don't rob the bank. Or there's somebody with a sniper rifle pointed at you and they'll kill you if you don't rob the bank. That's the duress. But normally the threatened duress has to be of an imminent nature. It's not a gradual turning of the screw, driving you crazy over a long period of time. In the Michael Barrison case, the right defense there, if you believed he was legally insane, personally, I have real questions about that. I don't think he met the very high threshold for insanity, but that would be the more robust defense than would be the excuse of duress. So that's this lawyer's professional opinion. Okay, check the super chats again. What happened? Sometimes, okay. Back to our pipeline of questions. We're down to the last few. This is from Jonathan. Any initial thoughts on the Patrick Loyola shooting in Grand Rapids? This might be a good podcast topic. Was the officer justified? I did. I covered that in a pod. I believe I covered it in a podcast. I certainly provided kind of an initial. Yeah, I wrote about it. That was about as clean a shooting as you could imagine. It's not even really close. He did everything possible to compel that officer to shoot him. So I don't have any qualms about that. I don't think the officer shot unintentionally. I think it's just a good shoot. I think it's ridiculous that much is being made of it. I think that Patrick Loyola brought this on himself, and he should not be surprised that he ended up getting shot. So, but if anyone's interested in learning more detailed analysis of that, you can just go to the lawofselfdefense.com blog, lawofselfdefense.com/blog, and we have a comprehensive blog post on that with video, I believe, of the shooting itself. Okay, so here we have another administrative question. Let me forward this on to supports. And back to the list. And this is the last question in the list. Okay, let's see what we have. This is from D. He writes, I came across this article from Caliber Press, which may provide some additional information pertaining to questions about a taser as deadly force weapon and an officer's reaction to a grab attempt. Is a taser a deadly force weapon? And by the way, the Patrick Loyola case that we just talked about in Grand Rapids was a case where he was being subject to lawful detention and arrest, and he seized control of the arresting officer's taser and refused to give up control of the taser, at which point the officer shot Patrick Loyola once, fatally. So the question here is, subject of this newsletter, is a taser a deadly force weapon when utilized by a resistive subject? And he, D provides a link to that video. I'll have to check it out. He says, additionally, some years ago, I sat a shift in a hospital room guarding a suspect who had been tased during his arrest. He was a heavy meth user, emaciated. I don't recall the exact details of the arrest, but when the deputy tased the suspect, one of the barbs passed between his ribs and pierced his pleural cavity, leading to a collapsed lung and hospitalization. As I didn't work with the narcs very often, I lost track of the case. So when we use force lawfully and otherwise lawful use of force, either a police officer lawfully using force to compel compliance with a lawful arrest or a citizen using force in lawful self-defense, what we're responsible for are the reasonably foreseeable outcomes of that use of force. To address the second part of this question first, if an officer uses a taser and there's something bizarre about the characteristics of the victim that the officer could not know, and it results in more serious injury to the patient than the officer could have any reason to expect, the officer's not expected to know things he couldn't be expected to know. Now, if he's had training, if this is a known issue, hey, if you're trying to taser an emaciated meth addict, the darts could actually pierce his lungs, cause serious bodily injury, and in that context, the taser's no longer a non-deadly weapon. Yeah, I mean, just as I would imagine, would you tase someone that you knew had a heart condition that made them vulnerable to death if tased? Would you taser a baby? Would you taser someone in a hot tub? I mean, I don't know that these things are remarkable risks for use of a taser, but if there were a known or should have known, was trained on, I should say, actually knew, was trained on an exceptional risk, well, then you're incurring that exceptional risk when you use that taser. And then you're perhaps knowingly creating a risk of death or serious bodily injury. And you ought to take that into consideration. The circumstances, the juice ought to be worth the squeeze before you do that, right? If you know you're creating a foreseeable risk of death or serious bodily injury, well, then the circumstances ought to be one in which you're also preventing a risk of death or serious bodily injury because you're stopping a deadly force threat. But if it's a freak accident, that is not going to play a role in whether or not the officer was justified in using the taser, especially if the use of the taser was otherwise consistent with his training, experience, and so forth. Now, I will say the next time this deputy goes to tase a emaciated meth addict, if the same thing happens, yeah, it could be argued that, well, he was put on notice the first time that a serious outcome, a deadly force outcome, serious bodily injury could result here. But absent that kind of prior notice, prior training, I don't see it playing any role at all. In terms of whether a taser is a deadly weapon when utilized by a resistive subject, my answer is yes. In my professional legal opinion, I think whether or not something like a taser or even pepper spray is a deadly weapon is partly a function of the intended or justification for the use of that weapon. I believe OC, a taser, used in a defensive manner. And by defensive manner, I also mean, I should say, a lawful manner. So obviously, when a cop is using a taser on a suspect, it's often as an offensive act by the police officer, but he's privileged to be the initial aggressor in making a lawful arrest, for example. So the cop may be the aggressor, the physical aggressor in the confrontation, but it's a lawful use of force by him. I think the lawful use of pepper spray and tasers is a non-deadly use of force because it's not going to be followed up. There's no expectation that it's going to be followed up by some subsequent unlawful use of force, more serious use of force. But when the same items, OC spray and tasers, are used offensively, unlawfully by criminals for criminal purposes, I would argue they are deadly force. The pain, burning, discomfort, disabling effect of pepper spray, the disabling effect of a taser, I would argue that qualifies as serious bodily injury, especially in the context of knowing the initial use was unlawful, and you could have a reasonable expectation it's going to be followed up by subsequent further escalating unlawful force. Someone pepper spraying someone because they don't want to be raped by the person they're spraying is different than a rapist pepper spraying a victim to compel her compliance with the rape. Those are not the same things. And the use of the weapon, the identical weapon for different purposes, makes it a different use. Very common, for example, in bank robbery cases, for bank robbers to go into the bank and basically hose everybody down with bear spray. And normally bear spray would be akin to pepper spray if used for otherwise lawful defensive purposes. It's a non-deadly use of force. But if you're using it to facilitate a bank robbery, it's the use of that spray is routinely characterized by federal prosecutors successfully as a use of deadly force, not necessarily force that can cause death, but force that can readily cause death or serious bodily injury, the pain and suffering, the burning, the disablement inflicted by the use of that spray. So yes, the reason why it's being used matters for sure. And that's why I would argue, like in the Loyola case, that when the violently resisting suspect seizes control and refuses to give up control of that officer's taser such that the officer is subject to disablement by that taser, the officer is in fact facing a deadly force threat in that moment, a threat readily capable of causing him serious bodily injury, disablement, and making him vulnerable to further violence by the suspect, including the suspect seizing the officer's firearm and using it against him. That's not speculation. That's reasonably inferred from the fact that the suspect's already violently resisting the lawful arrest being sought by the officer. All right, so I think that is, in fact, all the questions that we had lined up in our Platinum Q&A form. Let me take one more look to see if we have any super chats that need to be addressed. And we do. Let's see how we go. Someone, thank you for your super chat contribution, writes, I'm a new NRA instructor here. What should I look for regarding liability insurance for teaching CCW? So this is not my area of expertise. I don't teach as an instructor self-defense shooting anymore. I haven't for a long time. So I no longer carry insurance for that purpose because I'm not engaged in that kind of conduct. But to my knowledge, there are really two major, I guess there's three. Well, I think there's three entities offering this kind of coverage. Two for sure. One of them I'm less sure about, and I'm having trouble now recalling the name of the third one. The third one has been a sponsor of Armed America Radio. So if you go to Armed America Radio or armedamericaradio.com or something like that, if you Google it, you may see that there's an insurance sponsor of that program, and they would be the third entity. I'm not sure if they cover instructors or not, but it may be worth looking at, and I'm least familiar with them. But the other two companies I know that provide insurance for instructors, one is Lockton, that's Lockton, and they are associated with the National Rifle Association. So if you're an NRA instructor, you may very well already be getting advertisements from them. And the other major company is associated with CCW Safe. It's a division or component of CCW Safe. It may be set up as a separate, formally structured corporate entity, but it's part of that umbrella, and it's called FTA. I think it stands for Firearms Trainers Association, something like that, FTA. And they are a relatively new on the field compared to Lockton, but very, very rapidly growing in providing instruction to insurance coverage to firearms trainers. So I think a lot of CCW Safe as an organization. I know the guy at CCW Safe who is the leader on their FTA program. His name is Steve Moses. I like Steve a lot. I think he's got a former police officer, lots of tactical expertise. I've never personally dealt with FTA. I'm not a firearms trainer anymore, so I have not personal experience with being covered by them. But I would encourage you to take a look at what they have to offer, because I expect it's probably pretty competitive, perhaps superior to what Lockton has to offer. So those would be my recommendations. But again, really, I don't do tactical shooting instruction anymore. So you might just go out on some of the the instructor social media sites and see what other instructors recommend. But I know Lockton is kind of the traditional standby through the NRA, and then I would definitely encourage you to take a look at FTA as well, because I think they do good work, and a lot of pretty prominent instructors have shifted over to FTA. So I presume it's because they have some advantageous offer to make. Okay, folks. So let's see. I've been going for about an hour 20. Oh, here's another one. Let's see. Let's see. MM. Is that Eminem? Are you the rapper? You should have put an ampersand in there. Says, would you consider doing a series on the self-defense use of a vehicle in carjacking situations? There's lots of videos on YouTube to use as examples. I guess so. But there's nothing really unusual about it. It's the same analysis as if you were being subject to an armed robbery on a street corner, really, except for obvious differences that don't require much consistent, much rigorous further analysis. But you're in your car, you're approached by somebody with a gun. They point the gun at you, they say, give me your car. Just like with an armed robbery, you can hand over the wallet, right? You can get out of the car and give them the car. That would be one way to go. I mean, is a car worth killing somebody over? But maybe you don't believe you really can. I mean, you got a gun pointed at you. Are you in a position? Do you carry in such a way that you can access your own firearm, or have you trained in this? Have you practiced it? Have you given it mental thought? Drawing on a drawn gun is pretty sketchy. I will say, once you've given up your car, they're in the driver's seat, you're standing outside the car to shoot them, that's a more complicated issue, because then it can be argued that you're shooting then really only in defense of property, because they're not pointing a gun at you anymore. There's no longer an imminent threat to you. Unless there is, right? Unless you're kind of standing in front of the car somehow, and there's a fear they're using the car as the weapon. But the analysis is always the same. Are you, before you're privileged to use deadly force in self-defense, are you facing an unlawful imminent threat of death or serious bodily injury? There are moments in a carjacking scenario where you probably are, but where attempting to draw on a drawn gun may be imprudent. There are points in a carjacking scenario where you may not any longer be imminently threatened, and you don't want to be shooting people over property, because that's not lawful outside of Texas, at least, and maybe not there, depending on the circumstances. I mean, one complication, of course, is often when you're in a car, you're with other people, and it's not a simple matter anymore for you to simply exit the car and let them take the car with other people in it, especially if the other people are children. Then you can't give them the car, really. I mean, then you're compelled. And by the way, in that scenario, if you got out, they jumped in the driver's seat and were about to drive away, and there's kids in the back of the car, if you shoot them, then I would argue you're shooting in defense of the other innocent victims, the children in the back of the car. It's not a defense of property scenario then. It's a defense of others scenario. But you can see that the legal analysis is not super complicated. The same 5 factors apply as always. So if you came across a particular carjacking scenario video that you wanted me to comment on, feel free to email it to us or provide me the link somehow, and I'd be happy to take a look at it and see if there's something quirky about it that would justify giving it some exceptional attention. But most carjacking situations are just not that complicated. Let's see. All right, folks. Well, we've been going almost an hour and a half. I think I will wrap up at this point. It looks like I hit all the super chats, and I've got other stuff to do around the office. I'll close by reminding all of you, if you'd like to transform yourself from your current state of being easy to convict, and that's almost certainly your current state, unless you've worked through a lot of law self-defense content already. You don't want to be easy to convict, folks. If you're compelled to defend yourself, your family, your property, you don't want to do that and win that physical fight only to spend much of the rest of your life in prison after a multi-$100,000 legal defense that you lost. So don't do that. Don't be easy to convict. It's not hard to make yourself hard to convict. You just have to know what to do. And we help explain what to do in this series of free webinars, our hard to convict webinars. They don't cost a penny. They are limited to 100 seats. So when they fill up, I have to limit it so I can handle the Q&A that is at the end portion of that. They tend to run just under 2 hours in length. We do them around lunchtime. We have one tomorrow. That's April 27th, Wednesday, April 27th at 2 p.m. Eastern time. And then we have others on future Wednesdays, but I think the next one is 3 weeks or so down the road. If you go to this URL here, lawofselfdefense.com/hard to convict, you can sign up. There's a pull down list of dates. I think when I started this morning, this broadcast, there were still a few seats available for tomorrow. So you can grab one of those if it's available. If tomorrow's date is not listed on the pull down, it's because it filled up, and you'll have to pick one of the later dates then. But folks, when do you want to be hard to convict? A month from now or tomorrow? So I would encourage you to go to lawselfdefense.com/hard to convict and pick the earliest date that's convenient for you to learn how to make yourself hard to convict. All right, folks, I think that is all I have for all of you at the moment, except, of course, to remind all of you that if you carry a gun, so you are hard to kill. That's why I carry a gun. So I'm hard to kill. My family is hard to kill. Then I also encourage you to make sure that you know the law so you're hard to convict as well. All right, folks, until next time, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe.